We need to start. Throw away our Constitution. It's outdated, you can see. Protest groups who rally and march peacefully. Many of us thought Obama would help restore our civil rights. Again, we see the law's been trashed by this administration, spreading anxiety and fright. Congress dumped our Constitution. The Bill of Rights under attack. We still have no right to privacy with unwarranted wiretaps. Those deemed enemy combatants still endure their long ordeals. People still need to restore the right of habeas corpus. The Patriot Act must be repealed. We must tell it to Obama. This country must stop making war. All the people of Afghanistan don't want us there anymore. The U.S. must stay out of Iran. Bring those troops home right away. We need peace and civil rights to occupy the world and bring change to all the USA. Norman.
Happy birthday, USA!
238.
238 years old. Declaration of Independence, July 4, 1776. The U.S. Constitution, which we'll read parts of, signed on September 17th, 1787. It was ratified. They only needed 9 states to ratify it. And that's set forth in Article 7 of the Constitution. It was ratified on June 21, 1788. Anybody's birthday, June 21?
Yes.
All right.
Oh my God. Oh my goodness.
So you have something else to think about next June 21 when you turn 39. The Bill of Rights, the first 10 amendments, was ratified on December 15th, 1791. Anyone December 15th birthday? All right, just 21. And then the last amendment. How many amendments do you think we have? Anybody know how many we have?
20.
No, more.
27.
27. 27th Amendment, the last one, May 7th, 1992, was that no compensation can be passed and enacted during the term that the people in Congress are voting for their increase. They have to wait for the next Congress to be voted in before the money can be appropriated. However, most incumbents win, and so even with that, they're still in effect voting themselves their own raises. So I want to spend a little time before we start reading about the U.S. Supreme Court. Because the U.S. Supreme Court's becoming more and more of a problem, especially for what group?
Women.
All right. Okay. Now, first of all, our Supreme Court this year only handled 67 cases. So they sit in session for 10 months. There are 9 justices. Each one has probably on the average 3 or 4 law clerks who do most of their writing. So if you divide that, each of the justices, there's 9, they sit for 10 months, 67 cases. So what are we talking about? We're talking about a little more than 7 cases per judge, and over a 10-month period, that works out to less than a case a month for each justice. Yeah, right, Andy, I've got it right on the head. So when they talk about the Supreme Court, this is not the way it used to be. They used to take 100, 125 cases a year, and now It's almost 50% of what they did when I started becoming a civil rights lawyer. So the court is working a lot less than they used to. They have more resources than ever before.
Maybe we're better off.
That's, I was thinking the same thing.
With this court, maybe we're better off.
I don't know. Of the 67 cases this term, 2/3 of them, 44 of them were decided 9-0, unanimous. And some of the cases, the unanimous case on the privacy case, which was a very, probably I think it's the most important case this term, is that the cell phone. So what the court did unanimously, with Roberts being the person who wrote the decision so that he got everybody to agree, the police cannot search your cell phone, your smartphone, unless they get a warrant. And in that decision, Riley versus California, there's some really good language about the importance of technology and how it impacts on all our lives. And it also raises the possibility that with regard to the NSA, with what they were doing on the metadata, which Snowden revealed to us, there are two decisions, one out of Washington, D.C. by a justice named Leon, who, interesting, is sort of conservative, who blasted the government for keeping all that information on the phone calls. And the metadata just means that if I'm calling you, they have my phone number calling you, at what time of the day and for how long we talk. It doesn't have the conversation that we had, it just has the phone numbers, on the theory that if I'm calling her enough times, they have to kind of figure out maybe there's something going on, and if they find out that I or she is some radical leftist or supporting certain groups overseas, especially in the Mideast, maybe they want to get more information. What they then have to do is go get permission from the secret court, the Pfizer court, to then get the phone conversation. So the judge in Washington, D.C. said he thinks that's unconstitutional. There's a judge here, a guy named Pauly, who is in the Southern District, and he went the other way. So you got two cases now that are going to work their way up, and probably in 2 or 3 years when we come back again and do our 4th of July, the Supreme Court will address that issue. But the idea of the technology invading our privacy, this decision had some good language about that. On the other hand, there was a decision with regard to 5-4, where there were 10 cases that were 5-4. Justice Kennedy was in the majority each time. So what you basically have is 4 Republican appointees: Roberts, Alito, Scalia, and Clarence Thomas, who are conservative, all appointed by Republicans. And on the other side, you've got Breyer, who were appointed by Democrats, and the 3 women, who are now beginning to speak up more and more: Ginsburg, Sotomayor, and Kagan. Interesting, the 3 women, where are they all from?
New York City.
So, and we get a little, in the Wheaton College decision that they wrote yesterday, Sotomayor wrote a really strong dissent and took on the court. And she's been very good, especially on issues about inequality and poverty, probably because of where she grew up in a housing project in the Bronx. And she seems now to be getting her own stride of speaking out. Ginsburg has always been there, and Kagan, we'll see where she eventually goes. But in the 5-4 decisions, it shows a conservative agenda. And it shows that the court is very skeptical of campaign finance laws. Once again this year, they struck down where there were limits on individuals contributing to political parties and to candidates. They're also very skeptical of efforts to drive religion out of the public area. There was a case out of New York, I didn't know where it was, it's a place called the town of Greece, somewhere upstate New York, and they allowed sectarian prayer before the town hall meeting and the city council, and people thought, all right, that's a violation of the Establishment Clause, because almost all the speakers were Christian. And so I thought the court would knock it down. But no, the court said that that was okay. Another one of those 5-4, sure.
There was a previous precedent, though, the school prayer. Did this demolish that precedent?
Well, it's limited to prayer before a government town hall meeting or official as opposed to the schools. So I would argue that prayer in the school is still a no-no, but in this situation it is, and they claim, the town said, it was open to anyone. So a Muslim could come, a Jew can come, an atheist can come, but when you looked at the last 10 years, the only people who spoke were people who were talking about Jesus Christ, Christian, and all that stuff. So,
Except when this case came up, then there was a flurry of Buddhists and
all of a
Hindus.
sudden you're going to come speak.
Yeah.
Right. So I think it's a bad decision, and it's another example of at least the majority of the court, the 5, with Kennedy swinging to say that we're not going to remove religion from public life. And the third area that the court seems to be going on is any race-conscious decision by government is a no-no as well. And there goes the affirmative action programs that we've had for 40 years. It also supports corporate rights. We'll get to the Hobby Lobby case in a minute or two, as well as yesterday's Wheaton decision, which sets some really bad signals for all of us. And they also curb union power. There was a case called Harris versus Quinn. It's not Chris Quinn, it's Harris versus Quinn. And in the context of that, what the court was saying is that some government workers, in this case healthcare people, did not have to and were not required to pay union dues. So what do we have? We have an overview of this Supreme Court moving more and more to a conservative agenda with Chief Judge Roberts, who I always thought was very smart but very slick in some ways, making decisions to be narrow and bringing in the liberals. And even on the case of the buffer zones, where in Massachusetts at abortion clinics, there was a 35-foot circle and you couldn't go in to talk to anyone. A lot of people in civil liberties world, etc., we had in New York, we said that you couldn't have that kind of zone because you can't just choose one particular topic. If you have that decision and saying that people can't be within a certain area in front of a building, what about the union pickets? What about anti-war pickets with regard? In that case, Roberts was able to get all 9, including the 3 women, to declare that buffer zone unconstitutional. The First Amendment issue there trumped the women's issue. But with regard to Hobby Lobby, which basically relied on the Restoration of Freedom Act of 1993, what that says is that anytime the government subjects a religious practice, if there's a substantial burden, it's illegal. So what they did in Hobby Lobby, and people need to really look at this decision because it's an attack, I believe, on women's rights, is that it basically said that a profit corporation can impose its religious beliefs on the women workers there. And what it was that they didn't want to provide any contraceptive coverage for the women. Now all they have to do is fill out a form. The government picks it up, but they were arguing that that would make them, in effect, assisting in abortion. And the court bought it. And that too was a 5-4 decision. With regard to affirmative action, I mentioned that before. There was a case out of Florida, excuse me?
Voting rights also.
They didn't do it this year.
Oh, that was last.
That was last year.
Whoops.
Fixed it. There one good thing on death penalty, when we get to that in the Constitution, there was a case out of Florida where Florida had a rigid standard where if you were above a certain IQ, then you would not be exempt from capital punishment. And the court rightfully said the IQ can't be the only standard to determine whether someone is mentally retarded or didn't have the capacity to understand what was going on. But overall, when you hear about the U.S. Supreme Court these days, you basically have Republican appointees, conservative, 5 of them, Democrat appointees, 4 liberal, and in the 4 liberal are the 3 women, and the 5 men who form the conservative agenda not only are taking on union issues, but they're taking on women issues in the concept of freedom of choice. So we have to be very careful of that. All right,
Well,
enough.
reproductive rights.
Excuse me?
Contraception is reproductive rights.
I think that's what he
That
meant.
is true. All right, this year we have, especially as it's getting to thing, we have our borough president here, and we have a city council person here. And would you want to say something before we start reading stuff? Go right ahead. Do you want Ben Kalos, Upper East Side? I was at our press conference the other day. One of the people said he's the future. He's pretty good. And for me to say someone, an elected official, is pretty good means he's pretty good. I don't say that very much of anything. You want to say something?
I'll keep it very short. Courage. It's the courage to declare independence from a tyrannical monarchy. It's the courage to stand up for everything you were singing about, to make sure that our country remains what it is. To paraphrase our U.S. Senator and Benjamin Franklin, this democracy is yours if you can keep it, but the cost is eternal vigilance. And because of your leadership and because of the leadership of people like Norman Siegel, there will always be people advocating to keep our America what it should be and what it must be, and free. So thank you, and this is an amazing tradition. Happy to be here for yet another year. Neil?
I'm glad to be here. I really enjoy this, and I think actually the Citizens Union decision, although not this year, is one of the worst from my perspective, because it underlies everything that is in our democracy, and now it is reverberating to all the other courts. So that Citizens Union decision is horrific. Thank you, Norman Siegel.
Well, thank you, Gail. Thank you, Ben. Okay, so who's going to start reading the Declaration of Independence, especially under the rain? Okay, let's go. And we'll stay unless it really starts coming down, and then we'll just say we will partially rain down. Under the tree, if you want to, we can do that.
When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation.
Well, we want you to read some more. Here, come here. Just read the stuff in yellow. We hold these truths. Very important controversy about this next section.
We hold these truths to be self-evident, that all men are created
All
equal. All people, inshallah. That they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive of these ends, it is a right of the people to alter or to abolish it, and to institute new government, inshallah, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness.
Okay.
Free all political prisoners.
All right, who else wants to continue? You get a benefit if you read, you're under the umbrella. Who wants to go next? Ann?
Okay.
All right, okay. Here. So read the yellow stuff.
Starting.
Right here.
Okay, I can't be as dramatic as Judith, but
But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security. The history of the present King of Great Britain is a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over these states. He has refused his assent to laws, the most wholesome and necessary for the public good. He has dissolved representative houses repeatedly for opposing with manly firmness his invasions on the rights of the people. He has obstructed the administration of justice by refusing his assent to laws for establishing judiciary powers.
Sounds like Congress.
He has kept among us, in times of peace, standing armies without the consent of our legislature, for quartering large bodies of armed troops among us, for imposing taxes on us without our consent, for depriving us in many cases of the benefits of trial by jury. A prince whose character is thus marked by every act which may define a tyrant is unfit to be the ruler of the people. That's right. We, therefore, the representatives of the United States of America, solemnly publish and declare that these united colonies are, and of right ought to be free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved, and that as free and independent states, they have full power to levy war, conclude peace, contract alliances, establish commerce, and to do all other acts and things which independent states may of right do.
Okay, thank you. All right, now we're going to go to the Constitution. I want to tell you that we're reading from the Constitution, this little book that the guy over there with his bike and the purple shirt is always shy. Bill Dobbs gave it to me in the year 2004. So I thank Bill for it. All right, so now we're going to go to the Constitution. Now, remember the Declaration of Independence, and especially when Ann was reading all that stuff, those were the list of grievances that the people made as to why they declared themselves independent. And that was the beginning of the United States of America 238 years ago. All right, so the Constitution. We're going to deal first with the legislative powers. You guys want to read some of that stuff? No? All right, who's going to read? All right, come on up. Just read the yellow underlining so that we don't have to read the whole thing. Yeah. Article 1. This is all, Article 1 is about the legislative branch, the House of Representatives and the Senate.
The House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications required for election of the most numerous branch of the state legislature. Representatives and direct taxes shall be apportioned among the several states which may be included within the Union, according to these respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed 3/5 of all other persons.
First provisions of the Constitution.
The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof for 6 years, and each senator shall have 1 vote. The Vice President of the United States shall be President of the Senate, but shall have no veto unless they be equally divided. The Senate shall have the sole power to try all impeachments. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present.
Who got impeached in our lifetime? Which president?
Bill Clinton.
And soon
Yeah,
Obama.
that's true
They
too.
tried.
Judgment,
That's well, yeah. Of the full house? Just the committee.
Just the committee on Clinton.
On Nixon.
Nixon did it.
Well, that counts as there were articles of impeachment filed against him.
But he
And
resigned.
then he resigned. But just so you know, there's precedent that even when the president resigns, they can still go forward with the impeachment, but they chickened out.
Oh, okay.
judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor. The Congress shall have power to lay and collect taxes, duties, imposts, to regulate commerce with foreign nations and among the several states and within the Indian tribes, to declare war.
But they haven't been declaring war since World War II, and we still go to war.
The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it.
Almost finished with Article 1. All right, Article 2 now. Thank you very, very much. Who's going to come up and talk about the executive power? This is all about, come on up. Come on up. You?
I'll try.
Anytime Gail or Ben want to do anything. Okay. Okay. Okay, we got one over here. We got more to go. Yeah, that's the best thing.
The executive power shall be vested in a President of the United States of America. He shall hold his office during the term. Right, he. Yeah, there you go.
That's the way it's
During
always
the term
been.
of 4 years, and together with the Vice President chosen for the same term, be elected, and there's a lot of other stuff that's not highlighted.
But we keep checking other stuff.
No person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of President. Neither shall any person be eligible to that office who shall not have attained to the age of 35 years and been 14 years a resident within the United States.
I don't know about the 14-year thing.
He, of course, shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors.
Okay, now the third article is all about the judiciary. So anyone want to come up? Joan? Great. I want to thank Joan again for sending out those wonderful, wonderful press releases.
The judicial power of the United States shall be vested in one Supreme Court and in such interior courts as the Congress may from time to time ordain and establish. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states.
Okay, now we're going to move to the amendments. Remember, in the Constitution, there's 3 branches of government. The legislative branch, Article 1, the executive branch, Article 2, and the judiciary, Article 2. That's when they talk about the checks and balances. There's no balance anymore in any of those things. All right, amendments to the Constitution. The first one. Gail, you want to read the First Amendment?
I don't have it.
Okay. Ben?
We should all do it together.
All right, read it all together. It's a great one. And the First Amendment's really 5 different amendments. And it's very, very important. I love the First Amendment. Okay, let's go.
Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances.
Article 2, Amendment 2. Who wants to come up about the guns? Okay, come on.
If I can read it.
Okay. Amendment 2.
A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.
And it isn't.
Supreme Court has turned that one upside down.
Yay!
Let's go now to Amendment 4.
Read them.
All right, Amendment 4, very important, curbs on police powers.
The right of the people to be secure in their persons, houses, papers, all those papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized.
We can throw that one in the garbage pail.
Yeah, right. They can take anything they want.
Key word here, and effects. All that stuff on the cell phone is effects. And thank God they put, well, thank the Constitution, that they in fact put that word in there. Okay, Amendment 5, very important. Okay, we got it. Okay, right.
Right. No person shall be held to answer for a capital or otherwise infamous crime unless on presentment of indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against herself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation.
Close Guantanamo!
Yeah.
We're now going to move on to Amendment 8. Who do I have for Amendment 8? Going once, going twice, Jenny.
Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted.
Violated. Violated.
I represent a woman right now on my first murder case that I've ever done, and she's been in jail now 53 months at Rikers. We still can't get her out. So when they talk about excessive bail, that's excessive bail in the sense of no bail. 13th Amendment. Who do I got? Come on up. All right. Very appropriate to talk about the 13th. I see they've learned over the years which ones they want to speak to.
14, 15.
Okay, do them all.
Neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction. Congress shall have power to enforce this article by appropriate legislation.
Okay. 14th Amendment.
No state shall make or enforce any law which shall abridge the privilege of immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, or deny to any person within its jurisdiction the equal protection of the laws.
That's a nice one.
Due process and equal protection in the 14th Amendment, those are the elastic parts of the Constitution. We've been able in the last 60 years to use the concept of equal protection, meaning the law should be applied equally to everyone, and due process, which means fundamental fairness, to adapt to make the Constitution a living document as opposed to something that existed a long time ago. All right, 15th Amendment. 15th Amendment? Okay, we got 15.
The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude violated.
Right, but if you're poor, if you're poor and you don't have your birth certificate now, you can't register to vote anymore. Okay, let's move on to
Revealing my ignorance. Why is the Supreme Court appointed for life?
why they appointed life. Federal judges and the Supreme Court are appointed life because the Constitution provides for that. They wanted stability and continuity, whereas if you have the judges like in the state court system and they get elected every 10 or 14 years, they're afraid sometimes to do the right thing because the New York Post or the Daily News will put them on the front cover. So you don't get that kind of independence, and that's why I think the federal court, even with bad appointments, overall I think that's a better system to have them there, as so they can be more independent. All right, why don't we all read out loud the 19th Amendment?
The right of
citizens of the United States to vote
shall not be denied or abridged by the United States or by any state on account of sex.
Congress shall have power to enforce this article by appropriate legislation.
I've always wanted to think about it. It took until 1920 for most of you here today to have the right to vote. What does that say? It says not good stuff. All right, so we will have as our last speaker our youngest person who will read the 26th Amendment. I'll read it together with you. The right of, go ahead, right over here. Can you do it?
The right of citizens of the United States who are something.
Why don't we help her?
18 years.
Who are what?
18 years.
You can't vote yet, Marie.
Shall 18-year-old, God bless me. 18 years of age or older. Oh shit, I can't read it.
Okay, let's help her.
Older to who shall not be
abridged by the United States or by any state on account of age.
All right.
The Congress shall have power to enforce this article by appropriate legislation.
Yeah. All right. Okay, and for you, all right. I love you all, so thank you.
We
Get
love
home.
you.
Don't get too wet, and we'll see you next July 4th, 2015. Right. Sarah Lee and I went out. We had cookies and all kinds of stuff for you. But somewhere in the future, we will have that at our apartment. So thank you all. Enjoy the 4th. Bye-bye. Then I'll have it all up on YouTube. Thank you.